Yeah.
A neutral rule, but a neutral rule that you're consigned under based on the consciousness of your defining characteristic, which is protected.
Welcome to Oregon Law Lab. Today we're talking with Professor Michael Harper about two important Supreme Court cases, EEOC v. Abercrombie and Fitch and Young versus UPS. Why don't we start with the Abercrombie case? Can you remind us what that case was about?
A woman wanted to work for Abercrombie and Fitch, and she was a Muslim woman, a young woman, who wore a hijab to the interview. And Abercrombie was very careful in the way that people looked. And they had a policy against hiring anyone who or allowing people to wear caps at the workplace because she was wearing a hijab, it looked like, for religious purposes. And the person who interviewed her obviously was suspicious of that and talked to a higher up, and the higher up said, look, she's going to want to wear that, so don't hire her. The statute prohibits not only discrimination against religious beliefs, but also discrimination against religious practices, like wearing a hijab. And the question is whether, in order to there to be religious discrimination under Title VII, the employer has to know that there is a religious practice here. The court decides that under the particular language governing religious discrimination in Title VII, the employer doesn't have to know. But in this case, the employer was the least suspicious. The reason I wrote about it in this article that contrasted the decision in the pregnancy case is that it is treated as disparate treatment. The court considers this disparate treatment against the religious practice, even though the employer had this general policy against wearing caps or hats.
There are two different types of discrimination cases you can bring. There's disparate treatment, which generally involves some sort of proof of discriminatory animus,
or at least discriminatory consciousness, yes.
Yeah. And then there's disparate impact, where you don't have to show that. You're just pointing to a neutral rule that has a disproportionate impact on a group that's protected by the statute. And so what's unusual about this case is they treated this no cap rule as a disparate treatment case and not a disparate impact case.
I actually think it was correct to treat it as a disparate treatment case, because what happened here is they say, oh, you are wearing a hijab, we're going to put you in this category of cap wearers. But there is a consciousness of her religious practice, and then deciding, because she has this practice, she's going to be wearing a cap. So we're going to put her in that larger set of cap wearers. But in the pregnancy case, conceptually the same situation is the court. Everybody on the court says this is not classic disparate treatment. In that case, the woman has an inability to lift more than X pounds, which she has to lift as a UPS driver, and she wants an accommodation, the same sort of accommodation that the employer has given to other workers with other kinds of disabilities that prevented them from doing their job. The employer's policy only gave that accommodation to certain categories. And to simplify it, the biggest category is those who sustained their disability from the on-the-job injury. Now, pregnancy presumably is not an on-the-job injury. But the employer says, oh, your disability is from pregnancy. We're going to put you in this category of off-the-job disabilities rather than the category of on-the-job. That's just like, oh, you're wearing a hijab. We're going to put you in this larger set of cap wearers.
Yeah.
A neutral rule, but a neutral rule that you're consigned under based on the consciousness of your defining characteristic, which is protected.
They're sorting workers into buckets. The problem is that the employer is choosing to put them in that bucket. It's not an unconscious decision. It's not a neutral decision. It's like, what bucket? Okay, you go with the cap wearers. Oh,
Right.
Pregnancy, you go with off the job injury. And it turns out that bucket, it means you don't get a job or you don't get an accommodation.
Yeah. And in Justice Breyer's majority opinion, which he ultimately gets to a pretty good place, but he says that she wants to have most favored nation status for her pregnancy. She wants to be treated as well as any other disability. Well, that's what discrimination law gives you.
Right.
It generally says you get as good as anyone else gets.
With the most favored nation status, it seemed like as if they were saying she should be given the same accommodations as another pregnant woman with similar abilities as her, which just didn't make any sense to me, because then you're just going to treat all the pregnant women the same.
I don't understand. I don't understand the analysis. It's a very confused opinion. For someone like me who loves doctrine, it's very troubling. Justice Breyer, who I had, by the way, in law school as a professor.
You did?
Politically. He's very political.
Okay, you have to tell us what he was like as a law professor.
He was probably my least favorite professor in law school because he was so, on the one hand this, on the one hand that. He wouldn't draw lines. There are these factors that are relevant. And I did for administrative law, and it just, students generally don't like that. I don't think he was a particularly popular professor generally. Students like
popular professor.
And I think students generally like to be able to walk away with something to hold on to, that they've got some black letter that they can apply.
Yeah.
I do
And it was very difficult to extract that from him.
Here's the fact in the case that I just can't get over. So they said, we'll give you an accommodation if you have an on-the-job injury, or if we have to accommodate you under the ADA, or if your license has been revoked by the Department of Transportation, which could include like drunk driving. Like you got your license revoked for drunk driving and you get an accommodation and you get to, you don't have to lift, you get an inside job. But if you're pregnant, you go in the other bucket.
Right. It may be that these facts show that this whole system was set up with the idea of excluding pregnancy. And I think that's sort of where Justice Breyer gets at the end. He says, okay, this is not disparate treatment on its face, but the plaintiff might be able to show disparate treatment because there's really no good justification for the way they've carved this out.